So at this time, I'm going to start introducing our next panel. This panel is on free legal services. We all like free stuff. So this is the big one. So free legal services, learning about how law clinics and pro bono services that are offered to inventors are used here at PTO. So I'm going to introduce our moderator, John Kirkpatrick, and he will introduce his panel. And John, I'll go ahead and let you start with your lapel while I set up your presentation.
Testing.
Need to turn it on? There we go.
Here we go. Testing. Okay, good morning. My name is John Kirkpatrick. I'm an administrator with the Patent Pro Bono program, and I'm here to talk to you today and moderate a panel on our two legal services program. One of them is the Patent Pro Bono program, which I work on specifically, and the other is the Law School Clinic Certification program. And I just wanted to talk about one thing. When we talk about legal services, these are free legal services provided by either patent practitioners or law students. They aren't necessarily free legal services that the USPTO provides directly, because the USPTO can't provide legal services to you directly. We can only really refer you to other programs that we work with who provide the legal services. And I'd like to introduce my panel today. We have a collection of representatives from all our legal services program. First, we have David Henry. David Henry is a law professor at Baylor and runs the law school certification clinic program at Baylor, where he works with law students who work with applicants. Jim Brookshire is from the Federal Circuit Bar Association. Jim runs the program that serves Washington, West Virginia, Virginia, and Maryland. And so he has the experience of telling you what it would be like to qualify for the Patent Pro Bono program in that area and what would be expected. And finally, we have Kiri Sharon. Kiri is a private practitioner with Foley and Lardner. Kiri has actually represented a person in helping them get a patent, and she has some very interesting stories to tell about that. So with that, I just wanted to give you a bit of a breakdown of the services that we have to offer. First, we have the Patent Pro Bono program. The Patent Pro Bono program has been around for a while, but it really got full gas going in about 2015, where the USPTO even put a greater commitment forward, and we actually have national coverage. So just out of curiosity, how many people are from out of state? So really, I'm really surprised. That's a great number. And just so you know, every program that we are talking about today is national. So no matter what state you live in, there is either a law school clinic that will help you, or there is a Patent Pro Bono, what we call regional program, that covers your state. And we'll have some information about that coming up. It's basically, on the Patent Pro Bono side, we have 21 regional programs that provide coverage for all 50 states. We don't have 50 programs because you can't stick a program in every state. So the regional model really works best for us. As I said, we have nationwide coverage for the Patent Pro Bono program. And this is just a map. You can go to our website and see the same map. There is a slight change in the map in that we now have a program specifically for folks in Louisiana. Anybody from Louisiana here? Okay, well, if you know folks from Louisiana, you can go spread the word. So probably what you're most interested in is what are the criteria to participate in the Patent Pro Bono program. Generally, the partners that we work with look to household income. And right now, that's about, if you're a single person, no dependents, it's around $36,000 or lower in terms of income. If you have family or dependents, that actually increases, and in some cases, depending on the program that covers your state, it may be as high as around $72,000 of household income. So the program is designed to reach into people who really can't afford an attorney no matter what, and that we also know that attorneys in private practice, it's not cheap basically to work with an attorney to get your patent prepared and filed and prosecuted. And so we wanted to reach out to those people who really weren't going to be in the ball game but for this program. You have to have some knowledge of the patent system, and you're certainly getting some of that here today. We have a great online tutorial that's sort of a Patents 101. And I would suggest, even if you aren't interested in the Patent Pro Bono program or don't feel that you will qualify, I'd really just suggest that you check out that tutorial. It just goes over patents, it goes over foreign filings. It's a great thing to go through and just quiz yourself on your own knowledge. And then you can print yourself out a certificate at the end and frame it if you want to. But the other key thing is have more than an idea. And I think you all probably know that. I mean, you can't, if you just got an idea, but you can't describe what the inventive feature is, you can't describe how to make it, especially, probably aren't going to be going anywhere. So you got to have more than an idea. And these attorneys, when they work with you, they are really actually giving up a fair share of income to work with you. So they really want to work with people who have ideas and are enthusiastic about pursuing those ideas. The other thing we can't get away from is, even though the attorneys are providing free legal services, you still got to pay the USPTO fees. Generally, you're going to qualify as a micro-entity. You're going to get the 75% discount, but you still got to pay the USPTO fees for the filing and prosecution of your patent application. And also, some of the programs that we work with, they're going to charge a processing or service fee. Part of that is they want to see some commitment from the inventor. Part of it is they are bare bones nonprofit operations who are looking to recoup their costs for the work that they're providing for you. So to apply, it's very simple. You go to the USPTO website. Jim's group also offers what we call the National Clearinghouse. You can go to Jim's website, no matter what state you live in, fill out a form, and that form is going to get sent to the state that the group that covers your state, and they're going to contact you. So we got a couple ways to make it easy for you to ask about the Patent Pro Bono program and apply. We also have a nice email address that you can send us a message at any time. Next, I'd like to talk a little bit about the Law School Clinic Certification Program. So this is a little different. The Patent Pro Bono program is meant to involve private practitioners, corporate practitioners who want to do pro bono. Historically, patent attorneys didn't have the opportunity to do pro bono or free legal service in their area of practice. They would often have to go to more common legal services such as landlord-tenant, protective orders, things like that. But now they can actually do something that they are experienced in. And I think that's really important. So the Law School Clinic Certification Program, on the other hand, is trying to help law students under the direction of an experienced clinical supervisor like David get experience in working with applicants, filing and prosecuting patents. So you'd be working with a law school student under supervision of the supervisor, and you get a great quality of service that way, and that student really gets a step up for stepping out into the professional world. So I can tell you from personal experience, it's not easy to go to a law firm, sit at a desk, have a file put on your desk, and then say, oh, what do I do? So this is the law school program's goal, is to get those students ahead up. This is a map of the law school clinics we have around the states. The other important difference with the law school clinics is that not only do they do patents, but in some cases, in many cases, they also do trademarks. So when I talk about patent pro bono and private practitioners working on it, that's all patents. The law school clinics are set up to do trademarks and or patents. It depends on what the clinic has tried to do. Some actually do both, some do one or the other. And they offer a wide array of coverage. Some clinics provide national coverage. Some clinics want to focus on just helping folks in their regions. So we have another website. You go to the website and you can find out all the information you need there. Just a quick review of other USPTO resources. We have resources by state, and we want to let you know that if you're out of state, go to your state page. You're going to see inventor groups. You're going to see your local law school clinics that cover you. You're going to see your patent pro bono program that covers you. So you really want to take a look at your state page. And also, we have the Pro Se Assistance Program. So if you decide that you want to file your patent on your own, we do have folks available to help walk you through the procedures of how to do that. They can't give you legal advice because we just can't do that, but they can walk you through the procedures of how to do that. And we have the Inventors Assistance Center, which is once you get your patent filed and you're working on your own without an attorney, you can call in and ask questions of them. They are staffed at least, I think, about 10 hours a day. Finally, we have some resources for scam prevention. And one of the things with the law school clinic program and the patent pro bono program that we want to get out to you all is if you participate in them, we're hoping that at a minimum you get some education about your invention, because there are a lot of folks out there that are interested in having you pay a lot of money to offer you things that maybe the end product might not be what you expected. So we want to have your expectations set about your invention, whether that's good or maybe negative on your invention, and that's important. And finally, at USPTO.gov, we have just a lot of online resources. So that is the just brief overview, and now I'd like to go ahead and ask my panelists, who I'm very happy to have here, some questions. And we're going to start off with Jim. So, Jim, could you tell me a little bit about the Federal Circuit Bar Association?
Absolutely. John, thanks for having us with the group again this year. This is the most exciting part of the year for me. I bet there's one thing we all have in common. I bet we watch Shark Tank. It's a pleasure to be with you today. The Bar Association, which I'm privileged to oversee, is a national and a global enterprise. It reaches across the regions of the United States, the entire United States, as well as working with organizations overseas, including, there was reference to WO earlier, including WIPO and its own inventor assistance program. But our focus today is PTO pro bono. And we're fortunate in our Bar Association to have a large constituency of patent lawyers. We're fortunate to have a large constituency such as Kiri, who are committed to the system. That's an important, I think of it as an important distinction of our Bar Association. And as a benefit of that, we have lawyers who are interested in trying to be available. We'll get into more, I hope, John, as we go forward. There are limitations, constraints on that, which are important to remember. But the bottom line is folks want to help. We cannot, as an association, command them to help. They have a lot of constraints that govern their own professional lives. Maybe we'll get into that a little further.
Yeah, so how can an inventor apply to your program?
Two ways. I think of it as your program, the PTO pro bono program. My hat's off to PTO for having created the entry opportunity for folks who are not the multinationals, with whom we also deal in our Bar Association. The best way, John has already pointed out, which is the digital way, the web page. There are two ways to do that. One, if you're outside of our region being Maryland, Washington, D.C., Virginia, and West Virginia. If you're outside of that region, you come through the national portal on our webpage, It collects information digitally. There's often some understandable concerns among inventors. Do I really want to share details about my invention? Yeah, you should be thinking about that question. That's the right question to think about. The web portal is designed to invite only general information. That actually goes to a lawyer's consideration. A lawyer has to think about conflicts, a key phrase. I might in my day job do tech work. Well, if the invention is tech in an area where I'm also doing my day job, I may not be able to volunteer for the particular situation. So the lawyer has to have some insight to that. That's the national portal on the web page. The regional portal on the web page is the same, basically, also asking for information. It's routed to our regional offices. The national portal, we forward the information to those regions which John and PTO pointed out earlier around the country.
So we've mentioned the financial qualifications, Jim. What kind of screening do you do when a person applies?
The page asks for information on the financial situation. We have some staff, and then our regional offices look at the financial need question, as John pointed out, usually 300% of the federal minimum level, and that's a threshold. That is a threshold. A story for you. If we didn't apply that threshold, law firms themselves would, in considering whether they can make their lawyers available. They're good-spirited about it. They want to help. I'm being very genuine. They want to help. But they have resource constraints too. And so it's a question of allocating resource constraints. When you see that financial need question, it's more about allocation of resources.
If I qualify, what can I expect about a match?
The match, I checked last night, we actually have about, in our region, we've had about a match a month for the past 12 months, which is good for us. I think, let me, if I can, tell a story. I frequently get inventor calls. I've had 2 this week already. One happy, one not so happy call. I always begin with a little précis, an introductory remark, and I say, pursue all your options simultaneously. Do not bank on one option. You're inventors, you do that anyhow, but don't bank on one option. Our organization cannot guarantee at the end of the road that there will be a match. I can guarantee you that there's good-spirited intent, that there's goodwill among attorneys out there, but the match may not occur. When we pass through the threshold, the financial threshold, the application is actually distributed to attorneys. They have a certain number of days to respond. They'll look at the application, they'll respond if they have an interest. Put yourself in the attorney's chair. Attorney's got clients, she has to worry about conflicts. They've got family obligations at home. It may not be the time window in which that attorney can take the issue. That's just the reality of, again, the limited resource capability. We go through the distribution twice. If it's happy news, we let the applicant know that there's an attorney interested, and then we back out. The relationship that is struck is strictly the relationship between the attorney and the inventor, not us. That preserves your confidentiality. So in a real sense, we're matchmakers. We try to create the opportunity for the match to occur. We go through it twice. If there's no pickup by the second time, then we let the applicant know that there's no pickup and remind them of that first point that we make, pursue all your options at the same time. Hopefully something will come out. There are other options. One of the best ones sitting to my side, Law schools, I always refer applicants to law schools, to the clinics that are there. There are many around the country. I also always refer them to local bar associations, and then I refer them to state licensing bars. Pick a state, Maryland State Bar, where the lawyers get their licenses to practice law. They have pro bono programs as well. Pursue all these options at the same time.
Well, thanks. And this is a great segue into Kiri. You've worked with an applicant. Why did you volunteer?
Thank you. I've worked with 2 pro bono applicants, and I volunteered because it looked like a great opportunity to work on a patent application from scratch, all the way through to grant. So from preparing the initial application and prosecuting it through to the day when the patent issues, without the time and budget constraints that affect non-pro bono projects.
And how did you select a case? What piques your interest when you're looking through that email that Jim's sending out?
Thank you. Okay. What I looked for, so I reviewed the invention disclosures and material that came from Jim, from the Federal Circuit Bar Association. I reviewed that very carefully. And what I looked for was a sort of complete concept and something that showed me that the inventor had really thought about and had a specific thing in mind that they were focusing on, and could articulate that kind of in a concrete way. So my colleagues and I, we review these disclosures very carefully in making that determination.
So once you make a determination, then that person becomes your client, just as any other client, any other paying client that you might serve.
That's exactly right, and from that point on, the process is exactly the same.
But how is it different than working with a paying client?
Well, for one thing, many of our paying clients are highly sophisticated, international or large domestic companies, and so the people that I would typically be interacting with there already are very knowledgeable about patent law. And as you've probably realized, there's a lot of jargon in this field, and so the experience to really try to communicate clearly and explain something to a pro bono inventor as if I could, the way I would talk to a neighbor, and really try to make them comfortable with the process and explain what's going on. That's certainly a difference.
What do you find rewarding about working with applicants?
The sheer enthusiasm that the pro bono applicants that I've worked with have shown has just been great. It's also been a nice experience to work with the examiners. When examiners know that the applicant is a pro bono applicant, it's still the same examination. It's a fair examination. It's by the book completely, but examiners often, I have found, they do understand and acknowledge that the applicant is pro bono, and they do try to collaborate and work with the applicant.
And were you looking for an opportunity to do pro bono and patents specifically when you considered the program and considered signing up?
Yes, I had done pro bono work in completely other areas, such as immigration or trust and estates. In my own practice, I'm often involved in international work where when something is coming to me, that application was already filed somewhere else in another country. And so I'm picking up after the initial filing. And so with the pro bono program, that has given me the opportunity to really see things through from start to finish, which is just different. And another way that it's different is a lot of my day-to-day practice is in highly sort of computerized technology in the mechanical or electromechanical space. And I've had the privilege to work with pro bono inventors in one in interior design and another in sort of perimeter fence security system. So completely different. That introduced some variety into my day-to-day work.
Yeah, that's really good. It seems like a bit more tangibility to it too, because you can really see that product forming as you're working with the applicant.
That's right. And I'd like to mention just a quick story for one of the pro bono inventors that I worked with, who received her patent earlier this year. She has an interior design business, and she actually makes the product that that is now patented, and that's a window treatment. And so that's a real life thing that we were able to assist her with.
And David, you're our representative from the law school's program, and
Thrilled to be here.
Flew in from Baylor. We know you had quite a journey to get here. Why did your school decide to join the law school clinic certification program?
Well, we have had an interest in intellectual property in general for a while. We have an IP track for our students at our school. Baylor is very mission-oriented in terms of serving the community. We pride ourselves in turning out practice-ready attorneys in different fields. With frankly, recently, the explosion of intellectual property, actually in Waco, where Baylor's situated, it all fit very well. So this is all, but we wanted to give our students the opportunity to be practice-ready in the intellectual property field, and we wanted to serve the community. And this is just a perfect opportunity to meet both of those goals.
As a supervisor of the students, what experience do you have to have?
Well, you have to have been an actual patent prosecution attorney, USPTO licensed, registered as a U.S. Patent and Trademark Office attorney or agent. I believe the minimum experience is 5 years. Pardon me if I don't know specifically. I've had a good bit more than that, so it wasn't an issue. But you do have to have a good deal of experience to oversee these students, and you have to know much more than the students to oversee them.
And I'm sorry, but do you also do the trademark piece?
Yes, we do.
I recognize I should know the answer to that.
No problem. Yes, we do.
What can the students expect to get out of the program?
I would say from a law student standpoint, an almost surreal opportunity to work with real clients, with real projects, dealing with the passions and the enthusiasms and sometimes the disappointments. One of the things that I try to impress on the students is you are doing just as much a service to a client if we have to tell them, you're not there, or you're not there yet, or this is not something that you can get a patent, or this is not something you can necessarily protect as a trademark, just as much as if you get the patent or get the trademark, if it is available. Because as you alluded to in your introductory comments, there are companies and groups out there who will be more than happy to take all the money that they can from you to essentially seek to protect that which cannot be protected, or even if it could have been, perhaps not doing a well enough job. So our job is both giving sometimes bad news and good news, but in any event, the students learn a great deal and the clients benefit either way.
So if I'm interested in applying, what can I expect?
Well, in our particular program, and I'm sure this is fairly typical, we have a website portal where you can download, and you could, in our case, simply do an internet search of Baylor IP Clinic, and it'll pop right up. There's an online application. It asks a number of things, general information about what it is you want to protect, your information as the applicant. We are based, as has been mentioned before, primarily on income. We go the 3 times federal poverty level as a general threshold. Now, I will sort of override that on occasion. We have situations such as just this past week, a disabled veteran who actually the household income was above that, but all things considered, fairly qualified. So, but you'll have to give some introductory information so we can bring you into the system and determine whether or not we should take the next steps of getting more detailed information and see if we have capacity.
And one thing, we know that students come in and out of the clinic, so
Yes.
how do you manage that transition as patent prosecution, trademark prosecution can take longer than any one student being there?
Absolutely. One of the requirements for any of the students in our program is that they keep meticulous records, and we review them weekly in our lab meetings, sometimes we call them, meticulous records, and then at the end of their particular tenure in the clinic, they have to do a very detailed transfer memo, which is in the file so that the next student who comes along can read that and pick right up where they left off. And also, they are required to meet with their successor and sort of hand off the baton.
Similar to asking in the gym, what do you expect of applicants?
Assuming that they have a subject matter that we can work with, and you alluded to this earlier, not just an idea, but a fleshed out, ready to disclose in detail invention or a protectable trademark, that type of thing. We need engagement. You know, we are a community service oriented. We also have a limited time period with which to work. And to be honest, every so often we will have people in the program who they apply, they're admitted, and then they don't get around to responding for a good bit of time. We need engagement. We need timely responses. We need them to be part of a team. That benefits everybody involved.
And the team being the clinic and the inventor.
Absolutely.
Well, thanks. I'd like to really open it up for questions from you all because we often get into a really good back and forth. So I see one hand up over there at that table there.
One back here, too.
Yes. And the microphone's coming to you.
I was out for a couple of minutes, so you might have covered this. Are you allowed to, at the school level, to sign off for the patent to be submitted if you're not an attorney?
Well, the application is submitted under, in our case, under my supervision, but our students are actually provisionally admitted to practice before the USPTO, and so they are on the application, but everything is done also under the director or supervisor's authority and approval. Wow. So students aren't going off filing just completely on their own.
And I was just, well, thank you. That was
Certainly.
Great information.
John, there's one back here.
We have
too.
a question here.
Okay.
Hi, my name is Rita Crompton. I'm out of Colorado. I'm over here. For the people who don't qualify for the pro bono program, there's a new option called Archimedes Offspring, and anyone can apply to go through the vetting process and receive funding for that. And it works well with the pro bono program because what do you do after you get your patent filed? You need help with the engineering and the design work. But if you don't qualify, if you're in that space, we're an option. And if you want a flyer, you want some information, please stop over. I'll be here.
I just wanted to add to that also, many of our programs do a bit more than just the patent pro bono piece. For example, in Colorado, there's a Women Business Development Center.
I know about that there, but I'm more than happy to have more information. You don't qualify for this piece, but here's the next step, here's the
Right.
option, here, there.
Thank you.
Hi. First, I want to say thank you to you people because we know you don't have to be doing this, and we're grateful. My question is about the scope of the relationship. If it's determined that a good strategy is a provisional patent first, leading into non-provisional, would you assist with that? And the second part is the relationship over when the patent is issued, or are you available for some guidance after that?
Kiri, may I direct that to you?
Sure. So it's a good question. I know we at my firm, we have assisted pro bono applicants from the full timeline from a provisional to the conversion, where the applicant is responsible for those official fees, but not for the attorney time. We have typically done a disengagement at the time from the pro bono program at the time that the patent has granted, we do make sure that the pro bono patent applicant understands the annuities or maintenance fees which are due for utility patents, because those are critical. And after that, that's sort of a case-by-case basis.
I just say oftentimes, once the attorney has completed what you have agreed with them to do, they will sign off, and then you would go back to, say, Jim's program and request additional service or request an additional match. And it varies depending on what program you're working with around the country. We'll go over, I believe, to the right here.
Hi, thank you for all the classes. I applied to pro bono for 10 school and also for the California Art Lawyer. And I was accepted in the program, but my technology is advanced and I didn't get assigned any attorney. What is my next step?
So hopefully when I know California Lawyers for the Arts because they provide the service in California. Hopefully when they say, unfortunately, we can't find you a match, they give you alternatives. Now, granted, there aren't that many pro bono alternatives outside the law school and outside the pro bono program. So you really have to consider your options, and then you do have to consider whether you may need to find a patent attorney to work with, but hopefully they've given you the options in your area.
No, it's when you don't find any attorney, when they don't find any attorney, they don't respond to you, but I called them and they say they didn't find anybody, so I just wanted to know if they was having other solution instead of pro se.
You might look for some angel money.
Angel money.
Yeah, and see if you can make a persuasive case for that, at least enough to lubricate a paying relationship with an attorney.
Okay, thank you.
And I also know specifically that California will give you about 3 months. I don't know if that time passed for you or not.
Yes, they give me 3 months.
Okay. One thing, just so you all know, we don't tell the attorneys what cases to take. The attorneys pick the cases, so that's why we can't always guarantee a match. Yes, sir.
For the law clinics, do they take on those cases as well that an inventor has gotten issued patent but needs to go and do some kind of change or an additional patent? Do they take those on, those kinds of cases, more complicated cases?
If we have the bandwidth, so to speak, student-wise, yes. We will look at a follow-on patent, as it were. I mean, if you've come up with an improvement to something you've earlier patented, absolutely. There's no reason we wouldn't, if we have the student and overall bandwidth to do it.
Okay. Yes, ma'am.
Good morning. My name is Sharon. I've been doing a lot of research, and through my research, I've come up with a lot of questions. And I'm going to ask this one to you guys today, and no disrespect whatsoever. But one of the cases involved infringement from the attorney themselves. So do I need an attorney for my attorney? How do I choose someone that I feel is going to execute my desires with my patent honestly?
So you are saying you've worked with an attorney and
No, I have not. I just said I've been studying cases
This is a
and
what
different things.
if
Yes,
scenario.
and this person was infringed upon by the attorney he had hired to assist him. He took his design, basically.
Okay. Generally, I like to be optimistic about the patent bar and those attorneys who are registered to practice before the USPTO, that the likelihood of that happening is low. Granted, those things do happen, but likelihood of that happening is low. I think you should look at pro bono options, see if they apply to you, And those are situations that you have to be, you have to look out for. But first, you have to proceed. I think. And you also, we have a page that shows active practitioners on our website.
Okay.
If you don't see a practitioner there, if you see a practitioner there, you know that practitioner is in good standing with the USPTO.
Also, I have a question. Because of the expense and the time involved, pursuing a design or utility patent can be daunting for someone. Can it be better or less expensive for us to pursue the license to market aspect of it instead, or can that be just as costly and daunting?
That would be a decision that's out of our space and moves more into a bit of legal advice. So that's where you want to really talk to an attorney. I certainly am not an expert on licensing versus having a patent, and so I think that would be something you'd want to talk to an attorney about. We really focus on the patent piece here.
Are licensing attorneys and patent attorneys, can that be one and the same person, or are they?
Sometimes it can. Many patent attorneys do licensing.
John, I might just jump in. I think that a couple of important threads in your questions. One is there's that hesitancy of trust. Trust is at the core of an attorney-client relationship. If there's a hesitancy, then if I were looking for an attorney and I had a hesitancy, I wouldn't enter the relationship with the attorney. It's just that simple. The attorney is going to be asking herself the same question, because that water flows both ways in the situation. I think second thread of your question that struck me was, and you folks know this every minute of your lives, this is not just a patenting decision. This is a business analysis you're doing. You're thinking about commercialization. You're thinking about hoping to create an enterprise, make some money out of this idea. Those two, is personal opinion, those two are parallel. They should never be disassociated. There should be a comprehensive plan. Third observation, you are fortunate. I have to tell you, I've worked with almost every federal agency in my career. Almost every one. You're fortunate to be working with PTO. PTO is one of the most engaging government agencies in the federal system. They can only do their job. They're limited to only doing their job. They can't provide the legal advice. You heard that. But they are engaging and take advantage, make a use of that. Fourth, if I may extend the remarks I heard a couple of days ago. John, you might know more about this, but the average examiner, I think, only has about 19 hours to look at a patent, to do the research that's associated with it. Now, that's an average. But keep that in mind as you're thinking about your own invention, you're thinking about making your persuasion through your attorney to that individual. This is in part a human exercise. And you've got good people here, but it's a human exercise.
I think we have time for one more question. I'd also like to add, we have a break coming up, so if you have questions, the panel is still here to talk to you. Ma'am?
Hi, I'm from Memphis, Tennessee. I'm an old lady piano teacher. I've been using my device for 5 years and tinkering with it as I go. I was turned down by pro bono services last week, and I'm here because I was turned down to see what I could learn from you. I've been using the device in a prototype off and on for 5 years. So I was turned down because of prior disclosure to 5- and 6-year-old students and their parents. I walk into the school with it under my arm. I've used it, as I said. So I thought that was unfair. Apple Computer has a team of people who experiment with their product. My team is only my students, little bitty ones. So do I have another avenue to pursue for help?
Ma'am, I'd say that's a little bit of a difficult question because it does involve the law and the determination of whether something is patentable.
I've already had a result from other sources that it is patentable, and I got high marks for it.
I suppose you might seek a second opinion from one of these other sources we've talked about, just to be
Okay.
sure that is the answer.
All right? Thank you.
Yes.
Okay.
All right. I'd like to thank our panel, and I appreciate all the questions. We are about to take a break, so for those people watching online, there will be a 10-minute break that we are about to take. But for those of you in the room, if you didn't have your questions answered, there is a pro bono booth available outside as well. They can answer additional questions. And as John said, the panel will be here off to the side of the stage if you have additional questions directly for them. Thank you, panel, and I look forward to seeing you all back in 15 minutes.